Bismillahirrahmanirrahim. Today I'll be discussing Ijtihad. Ijtihad in Fatwa. Ijtihad is one of the most talked about subject of Sharia in Islamic law, and it is in a way the end goal of the discipline we are engaged in discussing the subject of Usul al-Fiqh. If one were to provide a short definition of Usul al-Fiqh, it is a methodology that encourages and regulates the exercise of Ijtihad. Ijtihad is also the principal vehicle of reform of Islamic law, combines the interests both of continuity and change, and it's highly recommended that it is not to be neglected. The position of the mazahib on Ijtihad is that it is a collective obligation or fard kifai of the community not to discontinue Ijtihad. I'll be looking at the meaning and definition of Ijtihad. It's the methodology of Ijtihad, and decline of Ijtihad, and Ijtihad in contemporary issues, and briefly how to position Ijtihad vis-a-vis Fatwa. There are some other topics, and these are actually, I'll be using my two chapters, one in Principles of Islamic Jurisprudence, the other Sharia Law and Introduction. Both of these have a chapter on Ijtihad. The first one is more explanatory. This one raises contemporary questions about Ijtihad, and in fact provides a new definition for Ijtihad. But when I said that it is the most talked about subject of Sharia, it is due to the decline of Ijtihad. People ask questions. Why is it not being practiced as much? Why is it not an engaging process of legislation and lawmaking in our times? Many have said it is because the conditions that must be fulfilled by a mujtahid are too demanding. Others say that it is the continuing hold of imitative scholarship in taqleed, and that still holds back Ijtihad. And background history, there was a time when scholars spoke of the closing of the gate of Ijtihad, Sad Bab al-Ijtihad. Some difficulties also arise due to the fact that the Usul al-Fiqh is a discipline and the theory of Ijtihad, they predate the national state, which is 17th, 18th century Europe phenomena. And they did not provide for legislation, parliamentary legislation, a formula that could relate directly to the experience of lawmaking as we have today. In fact, statutory legislation itself is a handicap for Ijtihad, in the sense that the law book defines the position the judge must take, and the need therefore is diminished for the judge to consult the sources of Sharia directly. Ijtihad did suffer a decline, but there was also a time at the turn of the 20th century when prominent ulama Muhammad Abdu and his disciple Rashid Rida and Jamaluddin al-Afghani, and they issued a renewed call for the revival of Ijtihad. It has not been discontinued, nor has it ever come to a standstill, but it is also the results of that call over a century ago. We have seen some good results, but of a limited type. Fatwa in Ijtihad differ in the sense that Ijtihad is more substantive juridical methodology or doctrine compared to Fatwa. Ijtihad must explain its evidential basis in the Sharia, and also Ijtihad is not in the form of just delivering an opinion. A fatwa can consist only of opinion, agreement or disagreement, whereas Ijtihad explains its evidential basis. Neither of them is a binding command. Ijtihad in fatwa consists basically of juristic opinion. They are still open to further deliberation, and the person to whom they relate to still have the choice either to act on it or not to act on it. Ijtihad literally means striving, making an effort. It comes from the root word jahada, ijtahada, to try, to strive. And this is the substance of Ijtihad. It is defined in the classical works of Usul al-Fiqh as total expenditure of effort by a mujtahid, a person who is qualified to carry out Ijtihad, in order to infer with a degree of probability and the rules of Sharia from their detailed evidence in the sources. The sources mainly refer to the Quran and Sunnah. There are two points perhaps to this definition. One, person who carries out Ijtihad must be qualified, must fulfill certain qualifications. And second, that he carries out this in his individual capacity. It is a broad concept. Historically, although we say that the Usul al-Fiqh, Islamic jurisprudence, is all about Ijtihad, it is a methodology for Ijtihad from beginning to end. Yet, this is in a broad sense. No particular procedure has actually been specified for Ijtihad, although there are suggestions, as I will elaborate, and no locus of authority in the state machinery has been identified. Its relationship with statutory legislation also remains something that has not been very clearly worked out. The qualifications that a mujtahid must fulfill, 5 or 6 qualifications. One, he must be knowledgeable of the Quran and Sunnah, and the usul in the furu of fiqh, in the positions of ijma. The usul al-fiqh, and then the substantive Islamic law in its various branches. He must know Arabic, must be knowledgeable of the custom and conditions of society. He must be an upright person. Most of all, that he must have the ability to formulate independent judgment. He must be also knowledgeable of the goals and objectives, maqasid of the Sharia. It is, however, not enough. We have had difficulty to identify mujtahidun. If I ask the question now, how many mujtahids are there in this country, in Malaysia, or in any other Muslim country, we would not know for sure. The reason for this is that we have not identified a methodology or a procedure. How we know the existence of mujtahid and whether they are or not qualified. It is interesting. Al-Ghazali, a towering figure of Islamic law and thought, wrote in his one of his works on Usul al-Fiqh that the mujtahid in our time is extinct. Many centuries later, a 19th century scholar Al-Shawkani explained this. Of course, it is a kind of the modesty of the prominent ulama that they do not declare themselves that I am a mujtahid. And interestingly enough, it is due to the same reason Al-Shawkani said, did he forget himself? He was a mujtahid, and yet he went on record to make that statement. The point I made that the qualifications demanded of a mujtahid are rather onerous. To this, Al-Shawkani has responded, they are not difficult, and they are not by any means excessive. It is a number of other factors, and he has actually recounted, given names in every generation successively that mujtahidun always existed, and they have conducted ijtihad. But it is due perhaps in our time to the prevalence of secularism and the hold of secularity over the institutions of state, in the fact that we now recognize the statute book as the only authoritative source of law in the land, that we have not actually left a room, space for either the mujtahid or the ijtihad that he carries out. But it is possible to integrate into ijtihad into processes of lawmaking, parliamentary legislation in modern times. As I would explain, contributions have been made as to how this can be realized. It is not beyond the capabilities, for example, of the universities and legal professions to combine their resources and to design perhaps courses of training, how mujtahidun can be trained and identified. This can be achieved by designing programs that combine the study both of traditional and modern disciplines, as this has been done and attempted in many universities, Islamic universities, yet need to be renewed and revised. And we are actually engaged in that process in so many ways, especially after the revival and resurgence, Islamic revival, Islamic resurgence. The thought came to us, how are we going to make our law in government to reflect our own heritage? And I will be making comments as to how this can be made. It was, this can be done. Abdul Wahab Khalaf, a well-known professor of Al-Azhar of 20th century, he made the remark that in our history, ijtihad was not an official function. Mujtahidun did their work away from the influence of government. But now that government has such an expansive influence and hand in almost every sphere of activity in education and training, the government must play a role in design, certification and diploma programs for the training of mujtahids. The theory of ijtihad entrust this to the mujtahid as in his individual capacity. But now we have moved from that position. Ijtihad must now be a collective endeavor to be entrusted in, according to Muhammad Iqbal, into the Muslim Legislative Assembly. His suggestion is that we now have no alternative but to entrust the Muslim Legislative Assembly with both the power of ijma to formulate consensus and also ijtihad. It is due to the sheer growth of the fields of disciplines and knowledge. No one individual can qualify. And the suggestion also has been made that we do not necessarily entrust this task to the faqih in the ulama of Sharia, but to include learned individuals and groups from other disciplines that are important to the society, contemporary society. And I have written that we should amalgamate ijtihad with the Quranic principle of consultation and shura and make this a consultative, collective endeavor. It is also ijtihad been understood as a juristic concept, due perhaps to the fact that historically Sharia as a discipline dominated almost all other disciplines of Islamic studies, and therefore Ijtihad was understood as a juridical concept. But this, as I have suggested, need not be the case. Perhaps in our times we may have cause to move from this particularity and open up the scope of Ijtihad. After all, Ijtihad is in the nature of striving, of research, of making an effort to find a solution to new issues confronting society. And these issues are not only now legal and juridical issues. There is no reason, for example, that a Muslim scientist or economist cannot conduct ijtihad in his own field of specialization, provided that he is knowledgeable of what we specified of the Quran and Sunnah, and have the capabilities to carry out ijtihad in his own areas of concern. It is a methodology of finding solutions to issues, and that is how I understood. In that light, I have also attempted a new definition that make adjustments to the existing definition of ijtihad and tries to encapsulate some of these new ideas. And in this book I have given this. It is ijtihad is a creative and comprehensive intellectual effort by qualified individuals in groups to drive the juridical ruling of a given issue, the hukum shara'i of a given issue, from the sources of Sharia in the context of the prevailing conditions of society. There are several elements in this definition, perhaps 4 points that to be noted. First, it is a creative intellectual endeavor. By this it means that reproductive effort that merely looks backward and is not creative would not qualify ijtihad. It relates more intimately to the prevailing conditions of society today. Often we look into the fiqh books and try to relate it to conditions. Now, this is not where this definition would suggest. And then it is not also a prerogative only of the scholars of fiqh in Sharia, but other, as I earlier said, learned individual in different areas and disciplines that are equally important for our society today. It is a comprehensive intellectual effort in the sense that it is not confined to one or two particular disciplines. And then I said that it is by qualified individuals in groups. That would involve parliamentary groups and other institutions of learning and research who will also be included. In other words, we have departed from some of those characteristics of the earlier definition of Ijtihad to some fresh understanding. Of course, definitions are always open to revision, and I'm not claiming that it would be the best definition, but it's an attempt in that direction. Discussing the methodology of Ijtihad, as I earlier said, the whole of Usul al-Fiqh is the methodology of Ijtihad. Yet, in the sense of a particular procedure, step by step, we have not specified one particular procedure. Looking back at the early precedent, especially the period of the companions, their way of exercising Ijtihad in finding solutions to new issues was to refer to the Quran first and then to the Sunnah of the Prophet in his example. And if they did not find a solution, they would engage in consultation and maslaha, deliver a ruling that would secure the benefit of society. This was their, to characterize their approach toward Ijtihad. Then the next generation, the generation of the Tabi'un, they faced more complex issues due to the expansion of the territorial domain of Islam, the fact that Islam in the Sharia came in close contact with other well-established traditions, the diversity of schools of thought and sects in various parts of the Islamic domains, and also the concern that many lesser qualified individuals conducted Ijtihad. This became a source of concern, for example, for Imam al-Shafi'i, who set about writing his Risala, for example, to articulate the theory of Ijtihad in the discipline of Usul al-Fiqh as he attempted in his works. There was a need for this methodology. Before that, this need was not so poignant during the time of the companions, but afterwards the need became prominent for developing guidelines for Ijtihad. And then we have these two broad and comprehensive features and positions taken. One by the Ahl al-Hadith, followers of the Hadith, the other by the followers of opinion, Ahl al-Ra'ya. This bifurcation is by no means mutually exclusive. The Ahl al-Hadith exercised opinion and the people of opinion followed the Hadith always. But this is a major kind of characterizations. In the Ahl al-Ra'ya, partisans of opinion camp, we have Imam Abu Hanifa is the principal advocate of Qiyas in Istihsan. As we discussed before, this was his contribution. His contribution in formulas for Ijtihad. Imam Shafi'i closely identified Ijtihad with Qiyas. He made a famous statement, Ijtihad is Qiyas and Qiyas analogy is Ijtihad, two words for the same purpose. In other words, he confined Ijtihad to analogical reasoning. Then we have other schools, the Maliki schools, who advanced the theories of maslaha in blocking the means or sadd al-zara'i. Imam Shafi himself in his school advocated the idea of presumption of continuity or istishab as a formula for Ijtihad. And later, as I have written, some modern developments about most of these ideas in our times in 20th century suggestions have been added, and I have looked at some of them in our writings. Each mazhab, in other words, made a new contribution as to how to articulate the formula of Ijtihad in accordance to their own methodologies, all designed to expound and articulate ijtihad. And yet today we find that most of their works, we are in need also to add our insights as to how to make ijtihad most relevant to our own condition. Some of the other aspects of the methodology of ijtihad that I would briefly mention, but the details I have written. One is divisibility of ijtihad, whether it is divisible or indivisible. Is it a monolithic concept, or can it be dismembered into different parts and segments? Majority of the mazahib says that it is indivisible, monolithic. It is a caliber and the state of accomplishment of a particular individual who attains to the rank of mujtahid, and that he cannot at the same time be a muqallid, an imitator. When you reach that level of thought and judgment and thinking, you cannot follow others. You cannot be at the same time these two things. And that was the majority position. But in reality, Imam Ghazali and others, and we can take this different view, that it is divisible. And due to the sheer bulk of knowledge, it is perfectly now feasible for scholars to specialize in different areas of Sharia, some in criminal law, some in jurisprudence, others in inheritance, family law, and this is now happening. People do doctoral level studies and beyond in particular areas. So it is now that ijtihad can be, in other words, particularized. The question arises whether the Prophet ﷺ himself carried out ijtihad. He was the authority. When he delivered a ruling, that becomes more authoritative than just ijtihad, which is a speculative opinion. But in reality, he has conducted ijtihad, especially in relationship to military and temporal issues and questions. And the classification of mujtahidun and muqallidun in different categories, I may agree or disagree with this, but there is this write-up that writers have classified the ranks of scholars into 6 or 7 categories. One is mujtahid mutlaq, absolute mujtahid, comprehensive in all areas of the Sharia. Mujtahid fil Sharia also. Then mujtahid within the confines of a mazhab, mujtahid fil mazhab, in one particular school of thought. And then below that, mujtahid in particular reference to particular issues, mujtahid fil masail, whether it is criminal law, inheritance, etc., etc. And below that, 3 or 4 other categories, those who are capable of extraction of correct rules, ashab al-takhrij, those who are capable of giving preference of some rules over others, ashab al-tarjih, those who are capable of correcting minor errors, ashab al-tashih, and identify what is the principal mainstream ruling in what is the Zawahirul Rawaya in the Nawadir, the rare opinion, and so on. And then, of course, full-scale imitators, muqallidun. As a matter of fact, the last 4 categories after the first 3 are all muqallidun, all imitators, because they do not innovate. And then there is a discussion about the truth and fallacy of ijtihad. Question here is, like the 4 mazhab takes the view that there may be several rulings of ijtihad on the same issue. Are they all true? The answer given is no. truth is one. Only one of the various ijtihadi ruling can be true and correct, and others are not. But the Ash'ari, Mu'tazila and others, they have maintained that plurality of ijtihad, several ruling can be correct. And when you look at the one hadith of the Prophet, it does seem as if there is some plurality accepted, that when the mujtahid carries out ijtihad and he reaches the correct solution, he merits 2 rewards. But if he falls in error, he still merits a reward. In the Quran, وَالَّذِينَ جَاهَدُوا فِينَا لَنَهْدِيَنَّهُمْ سُبُلَنَا. Those who strive in our path, we show them our ways. This is of course a general Quranic statement, but there may be room for both of these opinions. Partially perhaps correct, both of them. Then I discussed the decline of ijtihad. Until about 15th century, Common Era, Muslim scholars and ulama were able to adapt Islamic law in conjunction with the newly arising issues and to provide necessary solutions to problems of society. After that, in the last 4 centuries, that Islamic civilization encountered weaknesses due to the challenges of Western civilization, and there has been a decline in ijtihad, in intellectual originality. Kind of the Western domination robbed Islamic scholarship to some extent of their sense of originality, and self-image started on a declining course. The scholars of the era of taqlid, so to speak, of the era of imitation, they engaged themselves in writing glossaries and commentaries and on the works of the earlier scholars and imams, and originality of thought suffered a decline, and yet it was due to these reproductive works that they somehow give an aura of sacredness to the works of previous ulama and mujtahidun, to the extent that the mazahib themselves became the vehicles of taqlid. When the mazahib crystallized and became well established, they demanded scholars to follow the rule, the school of thought to which they belong, and that also impinged on the horizons of ijtihad and the originality of thought. The first 3 centuries of Islamic scholarship are known as the era of ijtihad. Restrictions were less, and after that we have developments I earlier referred to that increasingly restricted the exercise of ijtihad. Then of course we have colonialism and their domination, political and military domination of the Muslim lands. The first one of their priorities was to downgrade the Sharia and to declare it, only confine it to matters of personal law, and then in so many other ways to replace that with statutory codes of Western origin. And as I said, statutory legislation itself and the phenomena of the nation state also presented difficult challenges for ijtihad. In the era of constitutionalism, you have an authoritative constitution, and in most of the constitutions of contemporary Muslim countries, there is hardly a reference to ijtihad. The processes of lawmaking are defined, and we are further removed from the resources of our own heritage. And only in the 1960s we have this reassertion of Islamic revivalist demands that we must bring back. And then we hear of the revival of Islamic form of government and state, and gradually also developments, as I have explained. Islamic universities emerge, Islamic agendas of education, international conferences, and there is a great deal of activity and a great deal of constructive activity that tries to recapture the originality of thought and leadership that our scholars at one time enjoyed. The development of science and technology present challenges for ijtihad. We are falling behind because we don't relate. Ijtihad suffers, and the gap develops so much that it's becoming daunting to attempt it. The longer this gap remains, and we have had it for about 1,000 years, as our historic writing scholars tells us, the era of taqlid lasted for about 1,000 years. And that also brought us face to face with this phenomena, closing of the door of ijtihad. Then ijtihad in contemporary issues, I have elaborated a little the point that medieval era, the times, earlier periods were mainly, the scholars were concerned and faced with a number of challenges and issues that were on the whole predictable in the areas of marriage, divorce, inheritance, property, zakat, etc., etc. But that predictability is no longer the case. Ijtihad continuously is facing with new challenges in the area of governance. For example, our fiqh books are very elaborate on personal status, marriage, divorce, and so on, but not so much on the exercise of political authority, on the exercise of coercive power by the state organs, issues of financial products now, Islamic banking and finance, issues in science, labor relations, governance. These are areas wide open. Of course, 20th century scholars and after that, they have contributed, and yet the scale of development in this course, it must be a continuous and engaging effort for ijtihad to develop juridical rulings, for example, concerning whether cloning is permissible in Islam, whether this and that. All the time there are issues. In our own time, ijtihad, contemporary ijtihad, is operated in three areas. One, in the area of statutory legislation, I earlier mentioned, and yet ijtihad has been present even in this area. We have seen Islamic family law reform of the mid-20th century. We have seen new laws and codes of personal status in most Arab and Muslim countries that regulated polygamy and divorce through attempting novel interpretations of the Quran and the sources of Sharia in such a way to deliver different solutions. Polygamy was subjected to new restrictions, and so was divorce. to preserve the integrity of the Muslim family in times of modernity, in modern challenges. The second manifestation of contemporary ijtihad has been through the issuance of fatwa. We have seen collection of fatwa, like every prominent Shaykh of Azhar. Last thing that he writes even after retiring is a collection of fatwa, 2, 3, 4, 5 volumes of fatwa, and these contain a great deal of our originality in ijtihad, and their contributions are on record. And thirdly, third manifestation of ijtihad in our times are of course the works of scholarship by individuals and institutions. Muhammad Abdu invited attention in his call for the revival of ijtihad to two aspects. One, greater attention should be paid to the conditions in urf, custom of society, and to maslaha in the formulation of ijtihad. His disciple Rashid Rida also went on record to say that we ought to focus attention, give greater attention to the maqasid in the hikmah, the wisdom of the Sharia in the articulation of ijtihad. People often know what is lawful and unlawful, but they don't know what is the wisdom in the philosophy behind those. When you have a grasp of the hikmah, the wisdom of the ruling, then you have developed the internal capability of transforming yourself in your environment. To understand the hikmah, the philosophy, the wisdom behind the rulings of Sharia gives ijtihad a caliber of engagement that would otherwise be lacking. Some of the contributions, reform proposals made by Muhammad Iqbal, I mentioned already. We must, of course, respect the contributions of the scholars and imams of the past, but we ought to recognize equally importantly our own responsibility to exercise originality and revise some of those positions in the way that relate most meaningfully to our experience. And he highlights issues in leadership, for example, and others have written that now fundamental rights and liberties they pose issues for contemporary ijtihad, the prevalence of dictatorship, democracy, the understanding of jihad vis-a-vis violence and extremism, for example, gender equity and women issues pertaining to the experiences of the youth culture, the kind of exposure to modernity. These frequently poses new issues and new engagement for creative ijtihad. Muhammad Iqbal wrote that apostasy, the theory of apostasy, as you read in the Hanafi book Hidayah, it calls for a revision. The Indian subcontinent, many Muslim women, they convert to Hinduism, or because of the oppressive household and husband, and they don't find solutions from the Islamic family law, so they convert. And this is not what we should find adequate solutions to these challenges. Lastly, fatwa in ijtihad. The difference between fatwa and ijtihad, as I earlier mentioned, is that ijtihad is a more substantive juridical doctrine. But fatwa Also, if we consider fatwa and differentiate it with judicial ruling, a judge is only concerned with a set of facts, and he must have evidence. His judgment must be based on evidence. The mufti is not confined. The fatwa can be based on that evidence, but also the ethical and theological principles of Islam also must be integrated into fatwa. Ijtihad and fatwa, if they both explain their own evidential basis, then they are interchangeable, the same. Fatwa literally means a response. A qualified person, a faqih, may respond to a particular issue. But the difference between ijtihad contains an originality, something that is new, whereas fatwa can have original component, or it may be simply a reproductive effort, looking at the existing evidence and providing a response. Fatwa need not have that original component as ijtihad has it. In our time, fatwa has become subjected to changes. For one thing, in many Muslim countries, it has become the mufti is a state functionary. In earlier times, this was not the case. The muftis were like advisors, legal advisors, working with the community. If people needed advice in relationship to a particular issue, or whether a court case or a family problem or other, they would refer it to a mufti, and he would offer an opinion by way of making a contribution. That is no longer the case. The mufti is an official person, and restrictions have been introduced also through legislation on fatwa making. The ulama, for example, even in Muslim Arab countries, in this country, in Malaysia, they are not free now to issue fatwas. This must be exercised by the Islamic Religious Council, by mufti, and then to be endorsed and assented to by the sultan, and then gazetted, and then it becomes an authoritative fatwa. And when that becomes the kind of when all these processes are completed, then fatwa is binding. This must be complied with. It's almost another source of legislation now. This has not been the case as we understand in the theory of fatwa. Fatwa and ijtihad, they are both speculative in the sense that they don't bind anyone. If they bind anyone, it's the mufti and the mujtahid themselves, because they must speak out of their true conviction, and their true conviction, they must comply with it, ethically, morally, but no one else is bound by that. And they can ask for an alternative opinion, they may not follow it, but now we have changes, so many changes that almost influences the fabric of fatwa, of ijtihad in our times. I have written in some of the articles that we ought to not move too far in that direction. We ought to recapture the kind of openness of fatwa and ijtihad, that scholars made contributions openly to issues of contemporary society of their time. Of course, a judicial decision is binding, but that is the difference between judicial decision, qadwa, fatwa, and ijtihad. The latter two are not binding. The prevalence, of course, of statutory legislation nowadays restricts the scope of both fatwa in Ijtihad. We have in our history had this phenomena, although I have never found it easy to accept. Sad Bab al-Ijtihad, the closing of the door of Ijtihad around 5th or 6th century Hijrah, a climate of opinion emerged. From now on, no more original thinking, follow the mazhab. We are almost reaching that now. No more original fatwa, follow what is said. Almost closing the door of original thinking in fatwa. I think that benefits of introducing, and one must say this as well, restrictions on fatwa is that it prevents arbitrariness, arbitrary opinion. Irresponsible scholars stand up on Friday prayers and other places and deliver opinions that cause dissent and misguidance sometimes. And it becomes a source of worry for ruling authorities. That has become a big issue now. One would never advocate that, but a responsible exercise of fatwa by qualified people, we should open the scope. Thank you.